Okay, our first subject is actually one of my favorite ones to talk about, the Arizona Open Meeting Law. As you know, Arizona has a special open meeting law just for boards of condominium associations and planned communities. And what this law says is that any meeting of the association or the board of directors or regularly scheduled committee meetings must be open to all association members. So anytime that there's a quorum of the board discussing association business or a quorum of a committee that has regularly scheduled meetings, that meeting must be open to all members in your association. You have to provide 48 hours notice of that meeting to your members. Some of our clients provide notice in different ways. The law is kind of unclear as to what type of notice you should give. It just says conspicuous posting or any other means. Specifically, that's what the law says. So what does that mean for us as boards that are sitting here today wondering, is the notice that I'm giving good enough? Well, a couple things. First, putting a notice on your website is A-okay, as long as it's 48 hours in advance of the meeting. Some of my boards put notices at their guard gate, maybe sandwich boards, or they have a dry erase board where they announce the meetings. Some of our boards put it in newsletters. Some people send out emails. Really, it's pretty flexible, but just so be sure to meet the intent that you are providing information to your homeowners as to when the meeting is, at least 48 hours in advance of the meeting. Now, some of you here today may always have your board meeting the first Wednesday of the month at 7 p.m. at the pool. And one notice per year to your owners is enough to satisfy that requirement if that's when you always have your meeting. Now, if it's raining one day, then you're going to have to renotice it if you can't have the meeting on that date that you had previously published, and then give the 48 hours notice. A couple things on the open meeting law. Owners are allowed to attend, listen, and participate at appropriate times. So it has to be an open meeting. Owners are allowed to attend, listen, and participate. Now, for most of you sitting here, that's probably not a big deal. Because for most of you sitting here, you probably don't get very many people that come to your board meetings. But I'm sure that there are some of you, and by the way, just so you know, I always laugh when boards say that to me because that's typically a sign of a highly functioning association. So pat yourself on the back if you don't have high participation at your board meetings. That means nobody's upset or agitated with how you're doing things. Now, some of you may be sitting here and maybe you have what we call a gadfly. A gadfly is an owner who lives in the association who's unhappy with everything at the association. And maybe you have a gadfly that likes to come to your meeting. And the gadfly likes to contribute frequently, typically not in a positive way about the board, about just anything that's going on in the association. If you have that situation, your board has the right under the law to tell that gadfly that you can only talk during appropriate times at the meeting. And under the law, the only time that we're required to allow an owner or a gadfly to talk is before the board takes formal action on an item. Okay, so that would be anytime you're going to take a vote. So at a meeting, what are the things that you typically vote on? You may vote to approve your last month's meeting minutes. If the owner wants to contribute at that time, then that owner should be allowed to contribute. After the board makes the motion, there's a second, there's a discussion period. That's going to be the time where that person would be allowed to contribute. Now, if you're a board member here and you already have long meetings, you may be having some anxiety right now. And so what you may want to do is say, okay, if anybody in the audience wants to contribute, 30 seconds to put your contribution on the table for the board. You're welcome to do that. Another strategy that we find is very effective for open meetings and homeowners that want to participate in an open meeting is to have a homeowner forum at the beginning of your board meeting. And the purpose of the homeowner forum is maybe block out 10 or 15 minutes, maybe 20 minutes, and allow the owners to come in and comment about anything they want to comment about, and do that at the beginning of the meeting. But give them a time limitation if there's a lot of people that want to talk, and listen to what they have to say. Lots of times those owners will leave after the homeowner forum because they don't want to stay for the whole meeting. So that's also an effective strategy to allow homeowners to give input to the board. The board may also close a portion of the meeting and go into what we call executive session. Executive session is just the board and maybe your manager, maybe your attorney if your attorney is present, and you can only go into executive session for 5 different areas. And we have those 5 specific areas listed on the cheat sheet, right in the middle of the number 1 on the cheat sheet. In terms of the different areas, the first one is legal advice from your attorney you can go into executive session for. 2, pending or contemplated litigation. 3, personal health and financial information about a member of the association, an employee of the association, or a vendor of the association. 4, matters relating to the job performance of, compensation of, health records of, or specific complaints against an individual employee of the association or a vendor of the association. And last, this was added a couple of years ago, a discussion of a unit owner's appeal or a violation, penalty type thing, fine, imposed by the association, except upon request the affected owner may be able to ask to have it in the open session. So let's talk about what's the 411 on executive sessions. What does this really mean? First, executive sessions aren't mandatory. The way that the statute is written, it says that you may go into executive session to discuss these topics. It doesn't say shall, it says may, so it's optional. But as an attorney practicing in this industry, best practices is that you want to go into executive session when you're talking about executive session topics, okay? What are the most common executive session topics that I see? Going to a lot of board meetings, typically your board will go into executive session to talk about legal advice. An example of this would be maybe if your lawyer does a status report for delinquent files, opinion letters from your lawyer. Maybe you have a board member that called your lawyer and asked for some advice, or emailed the lawyer and asked for some advice. Any relaying back of the advice from the attorney can be done during the executive session. That's the most common one. The second most common one are delinquencies and violations. Going through the delinquency list, people that are in collections, looking at what the management company's doing, looking at what the attorney's doing. The third topic that we don't see as often, but we do see from time to time, is if you're unhappy with your vendor, you can go in and talk about your management company, your landscaper, your pool person. That's totally fine to talk about, their job performance. But one pointer where I see a lot of mistakes by boards is they like to, hire or fire your vendors during the executive session. That's not appropriate under the law. It's a distinction. You can talk about them, you can talk about how bad they are or that they're not doing a good job, but when you go to actually fire them or hire them, it needs to be done in the open session. Now, some of you might be sitting here and the hair on the back of your neck's going up because maybe you violated this in the past. Here's what I can tell you, just do it right going forward, okay? Make an effort to do it right and to comply with the law going forward. An interesting law that went into effect a couple years ago is that homeowners are now permitted to record audio and video and/or video at open board meetings. Now, when this new law went into effect, we thought that there was going to be a lot of homeowners that would be showing up with their video cameras. I have to say, I probably go to, 3 or 4 meetings a week at least. And really, I only see 1 or 2 audio or video taping of meetings a month. So it's maybe, somewhere 20% of the meetings that I attend, people actually do this. Typically, it is a disgruntled owner that is upset about something, that is videotaping. They're allowed to do it under the law. If you want to set up rules on how they are videotaping, like giving them some parameters as to how they can do it, etc. We have a cheat sheet on this. So go to those little flash drives that we gave you on the table, and you can look at our cheat sheet. It's called Recording Board Meetings. Arizona Open Meeting Law and Recording Board Meetings is on the back side. We give you some rules, sample rules that you can pass. So that is the skinny on the open meeting law. A couple things, just pointers on this. Where do boards get into trouble with the open meeting law? Probably the 2 areas that I would see are they go into executive session for the wrong topics, or maybe they go into it for the right topic, but then they cross over and they start talking about a budget or an item that's not in the executive session. So that's number 1. The second problem area that I see violations of the open meeting law are emails. Be careful on emails. I'm pretty confident that I'm going to go back to my office this morning and check my email, and there will be at least 2 open meeting violations where I've been copied as the association's attorney by the board discussing an issue. So let's just talk real briefly about email. When can you use email as a board member? What's okay? It's okay for less than a quorum to communicate with each other as a board via email. So number 1, less than a quorum, okay. Number 2, if your board wants to make a decision outside of the open meeting law, it's okay to do it as long as you have unanimous written consent. So if you have 5 board members and you decide you want to fire your management company, 5 out of 5 would have to write, in an email or handwriting on a piece of paper, most of our clients are doing email now, that they vote to terminate ABC Management Company. And that is sufficient under the law. Now, a good practice pointer is if you are making decisions via unanimous written consent, you will want to attach those consents to the next board meeting that you have for your association. So there's a paper trail in case any owner asks, what happened with, when did ABC Management Company get fired? Where are the minutes? You can say, well, it was done by unanimous written consent, and the consents are attached to the February 2016 minutes. Another area that you can use email is in emergency circumstances. If circumstances dictate, and this is right in the open meeting law, that the board must take immediate action, the 48 hours notice rule is suspended, and the board can make a decision with as many board members as they have available to make the decision. Now, what's an emergency, right? I have some boards that try to test that a little bit. Be careful about that. An emergency is a tree falling on the clubhouse. We had a case recently with that 500-year storm, or whatever they're calling it now, 400-year storm, where we had some serious damage to an association, water damage due to that storm about a year and a half ago, where people's homes were being flooded. So you have to get advice. You usually know it when you see it. So that would be a suggestion. So those are the 3 times that you can go around the open meeting law.